The petitioner filed a petition for voluntary insolvency, and the court sent notices to all the creditors mentioned in the petition, asking them to file an answer to the petition or a comment on the petition. They failed to file their answers, they failed to file their comments. And the petitioner filed a motion to declare all his creditors in default because there was no answer, there was no comment. The court refused to declare them in default. Is the refusal of the court one to be interpreted as a grave abuse of discretion? Answer the question. Did the court commit a grave abuse of discretion for refusing to declare the creditors in default despite their failure to file a comment or to file an answer to the petition for voluntary insolvency? Answer: the court cannot be considered to have committed a grave abuse of discretion because the petitioner, in moving to declare his creditors in default, is invoking the rules of court. The concept of default is in Rule 18 in the Rules of Court. He cannot, as a matter of right, invoke the rules of court because this is an insolvency proceeding. The rules of court cannot be insisted upon. As a rule, it does not apply. How do you know that? It's in Section 4 of Rule 1. If you look at Section 4 of Rule 1, it makes reference to the non-applicability of the rules of court on certain proceedings, even if they could be judicial proceedings. And the rules of court includes the rules of evidence. So the rules of evidence also belong to the doctrine under Section 4 of Rule 1. A motion to declare a defendant in default or a creditor in default is a motion that invokes the application of the rules of court. But the rules of court, they don't apply to insolvency proceedings, cadastral cases, land registration, naturalization, and even elections cases, even if they could be in the court. Di lalo na ang rules of evidence, in Rule 128, the definition of evidence refers only to judicial proceedings. Now, one more. I remember that famous case, it's very famous, that case of Bantolino versus Coca-Cola Butlers. Bantolino and his co-workers were dismissed by Coca-Cola Butlers Philippines Incorporated. They filed a case, a complaint for illegal dismissal with the labor arbiter. The labor arbiter sustained the complaint for illegal dismissal. Then the employer went to the NLRC by way of appeal, and the NLRC affirmed the illegal dismissal case. So the Coca-Cola Butlers go to the CA, and what was the grave abuse of discretion they raised? It was this, that the NLRC as well as the labor arbiter gravely abused their discretion in deciding in favor of the workers and employees. Why? Because in deciding for the workers, the NLRC took into consideration the affidavits of the workers, but the workers were never cross-examined on their affidavits. In plain and simple language, said the lawyer of Coca-Cola Butlers, they admitted hearsay evidence. Because an affidavit that is not subject to cross-examination is hearsay. That's true. You cannot simply go to court, present an affidavit, and then you do not cross-examine the guy, the affiant. That was the grave abuse. See? What did the CA say? Correct. There was a grave abuse of discretion. We cannot use hearsay evidence. So Bantolino and the co-workers lost in the CA in their petition for certiorari under Rule 65. There's no way to go to but the Supreme Court. So what was the issue of law? may the NLRC use the affidavits in its decision even if the affiants were not cross-examined. What did the Supreme Court say? No. The hearsay evidence rule is a rule on evidence. The rules on evidence cannot be insisted upon in a non-judicial proceeding. The CA committed an error. In the NLRC, which is a quasi-judicial body, it could even use evidence which, if used in court, cannot be admitted. But this is not a judicial proceeding. It is a quasi-judicial proceeding. In Sasan versus NLRC, binatikos din ang NLRC dahil it admitted in evidence a photocopy of a document. Sabi nung nagreklamo, hindi ito ang best evidence. Sabi ng Supreme Court, huwag mo na ipagdiinan niyang best evidence rule. That is a rule on evidence. And the rules on evidence cannot be insisted upon in non-judicial proceedings. You remember our case yesterday of Ong Chia versus Republic? Ong Chia versus Republic involved a Chinese national who applied for Philippine naturalization judicially. Then the RTC, which of course has original jurisdiction over cases like those, decided in his favor and that he was qualified and that he did not possess any disqualification for naturalization. The Solicitor General appealed. And for the first time, the Solicitor General and the government offered evidence which was not offered in the lower court. The evidence was a documentary evidence showing that Mr. Ong Chia was not morally fit to be a Filipino. It was admitted by the CA. And the CA said, I have to reverse the RTC. Mr. Ong Chia is not qualified because he is not morally fit. So Ong Chia wanted the RTC. The government appealed to the CA. The CA decided against Ong Chia. So the question was this: is it proper under the law for the CA to receive evidence for the first time on appeal? Evidence should be presented formally down below in the trial court, because that is where the formal offer of evidence is made, not for the first time in the CA, because that is unfair. The CA is an appellate court. It should only rely on the records of the case below and should deal only with errors of judgment raised from the trial court to the CA. According to Ong Chia, even Section 34 of Rule 132 of the Rules of Evidence say, the court shall consider no evidence which has not been formally offered. Where do you make the formal offer, he said? Not on appeal, but in the trial court. Now, how was this resolved? Answer: you are insisting on a rule of evidence. But the rules of evidence do not apply to naturalization cases, because the rules of evidence are parts of the rules of court. And Section 4 of Rule 1 says the rules do not apply to naturalization cases. There is a difference between proof and evidence. And what is it? Proof is only the effect of evidence. Evidence is the means to establish proof. But one central concept which we do not realize is very important. It's not the term that is important. It is its application that is important. Let's go to the definition of evidence. Evidence is the means sanctioned by these rules of ascertaining in a judicial proceeding the truth respecting a matter of fact. Okay, now, what is the purpose of evidence? To ascertain the truth. Of what? Of a fact. It's not to ascertain the truth of a law, but of a fact. You do not present evidence to prove the truth of a law. First reason, with respect to Philippine laws, there is a mandatory judicial notice of laws, the official acts of the legislative and the executive departments. they go together in the enactment of a law, right? Legislature makes a bill approved by the president, it becomes a law. There is judicial notice under Rule 129. And that judicial notice is a mandatory judicial notice. And there is another reason why we are not supposed to quarrel about the truth and the existence of a law. Because every one of us is expected to know the law. If everyone is expected to know the law, let's not quarrel about the law, because we presume you know the law. And ignorance of the law excuses no one from compliance therewith. So we don't quarrel about the law. We quarrel about facts. We quarrel about a fact like this. Si Maria ba ay maganda o hindi? O mag-aaway tayo. Now, so what are you supposed to prove in evidence? The truth of a fact. On the other hand, the other one will prove the falsity of that fact. Yan ang ating pinag-aawayan. And what are you going to prove? The issues of the case. You are not supposed to prove a non-issue because you will be irrelevant. Your evidence will be irrelevant. You prove an issue. You prove a fact. You quarrel on the truth of a fact. That which you are supposed to prove is called the Factum Probandum. Mr. X filed an action for damages. Is there a Factum Probandum? I filed an action to collect a sum of money. Is there automatically a Factum Probandum? There's none. The mere filing of a complaint will not automatically give rise to a Factum Probandum. Because the plaintiff still does not know exactly what he is supposed to prove. He has to wait for a responsive pleading from the defendant. The defendant says, your complaint says that I borrowed 1 million pesos from you. In the answer of the defendant says, I am a guy who always tells the truth. I admit I borrowed. Therefore, there is no Factum Probandum as to the existence of the debt because he admitted the debt. The plaintiff does not have to prove the debt. If he proves it in court, what are you going to say? Already admitted, Your Honor. The court will say sustained. You don't have to prove it. He admitted it. Second, the debt is due. Answer, admitted, due. Next, I demanded payment upon him to pay. Answer, yes, he demanded. Admitted. So is there a Factum Probandum as to the due date? There's none. Is there a Factum Probandum? Does he have to prove that he demanded payment? No more, it's admitted. He said, despite the demand, he did not pay. Answer, I paid. I have a receipt. There is now a Factum Probandum. There is an issue. The issue on whether there was payment or non-payment. You have now to prove that there was no payment. He will prove that there is payment. There is a Factum Probandum. Suppose he says, hey, I am ashamed, but I did not pay. There is no Factum Probandum, right? He does not have to prove that there was no payment because the son of a gun already admitted there was no payment. So because there is nothing more to prove with respect to the elements of collection of a sum of money, what are those elements? The existence of a debt, the due date or maturity date, the demand for payment, and the failure to pay. Complete. All admitted. If all are admitted, there is no issue. There is no issue of fact. If there is no issue of facts, there is nothing to prove. If there is nothing to prove, you don't need evidence. If you don't need evidence, there is no need for a trial before the judgment is rendered. You only have to rely on the complaint and the answer. And the answer and the complaint are pleadings. Go to civil procedure in relation to evidence. The plaintiff will simply file a motion for judgment on the pleadings. In other words, if you relate it to evidence, a judgment on the pleadings arises because there is no Factum Probandum. There is no issue of fact. There is nothing more to prove. No need for trial. Only the pleadings. Okay, let's try it. You accuse a person of homicide. An information for homicide was filed against Mr. X. What's the factum probandum? Na-check. You have to wait for the arraignment. He says, I plead guilty, Your Honor. Oh, does the prosecution still have to prove his guilt? No more. He admitted the homicide. But the court has a discretion on this. The court may require the parties to present evidence, not to prove the guilt, but simply to determine the imposable penalty. There might be mitigating circumstances. There might be aggravating circumstances. The evidence will help the court. But there is no more factum probandum as to the guilt of the accused. The prosecution does not have to prove it. And homicide is a non-capital offense. Right? It's only punishable by reclusion temporal. Now, could you check your Rule 116 for a while? Because I think the doctrine there was the one we used right now. Could you check your Rule 116, Section 4? Did you see it? Is it a plea of guilty to a non-capital offense? Okay? The court will not require the prosecution to prove his guilt anymore. But the court may allow the parties to present evidence simply to determine the penalty to be imposed. Right? Now, suppose the case was rape with homicide. That's a capital offense. Although, under Republic Act 9346, the death penalty will not be imposed. Now, so Mr. X committed rape with homicide. He was accused under an information for rape with homicide. That is a heinous crime, capital offense. Okay. Now, Mr. X, what is your plea? Binasang information. I plead guilty, Your Honor. So there was a plea of guilty. Is there still a factum probandum? Meaning, is there still something which the prosecution has to prove? The answer, is there still a factum probandum? Yes. If it is a capital offense, a heinous crime, although death will not be imposed, there is still a factum probandum. There is a duty on the prosecution still to prove the guilt of the accused. Not only the guilt, but also the precise degree of his culpability. And the court has another obligation, although this is not factum probandum on the court. The factum probandum is on the prosecution. The court has to conduct searching questions and inquiry to determine whether my plea of guilty was voluntary and whether or not I had a full comprehension or full understanding of the consequences of my plea of guilty. Look at Section 3 of Rule 116. You will notice there is still a factum probandum. You will notice too that the prosecution will be required by the court to prove the guilt of the accused and the precise degree of his culpability. Assume, I filed an action for damages against the defendant on the basis of a quasi-delict. So this concerns an act or an omission constituting fault or negligence where the act or omission causes damage to the other, and that the act or the omission was the proximate cause of the injury of the other, and that there is no pre-existing contractual relationship between the parties. I said in my complaint, that guy was driving his car and he was strumming his guitar while driving. His car rear-ended my car. I lost consciousness. My car was damaged. I was hospitalized. Answer of the defendant. True, I was strumming my guitar. I was singing an Elvis Presley song. And in the process, I was closing my eyes. And when I hit a high note, I closed my eyes more intensely, and I hit him. Because of my negligence, I destroyed his car, and his neck was broken, and everything in him that could be broken was broken. Plaintiff said, I was hospitalized, and I was severely injured, and I paid 3 million for my hospitalization. Answer, I admit everything you are saying, matigil ka na lang. Is there a factum probandum? Mukhang meron pa. Sir, inamin na lahat Oo nga. Pero mukhang meron pa kung babatayin mo ang rules. Inamin ang kanyang kasalanan, ang negligence, inamin na may damages yung tao. At maalala nyo sa civil procedure, material averments or material allegations not specifically denied are deemed. Kailan? Hindi kasama ang admission ng unliquidated damages. Tingnan yung Rule 8. Merong hindi kasama sa admission. Tingnan mong Section 11 ng Rule 8 kung yan nga. Look at the first sentence. Other than those of unliquidated damages, the amount ang hindi admissible. Hindi na-admit ang amount. Ang na-admit, the existence of damages, but not the amount. Okay, mga material allegations not specifically denied are deemed admitted, correct? Pero merong exception. Other than as to the amount of unliquidated damages. Inadmit niya, nakadamage siya. Pero, yung amount, hindi pina-admit ng law. Bakit hindi pina-admit ng law ang amount? Unliquidated yan Hindi naman yan previously agreed upon. Now, doon sa sitwasyon binigay natin, ang damages doon yung actual or compensatory damages talaga. And under the law, actual or compensatory damages cannot be given without proof. May full-scale trial ba as to the amount? Maaaring wala Kasi, pwedeng mag-render ng summary judgment ng court kasi ang pinag-uusapan lang is the amount of damages. Would you go to Rule 35? Go to Section 3. Pwedeng mag-render ng summary judgment kung ang pinagtatalunan lang ay amount of damages. Kasi ang issue, hindi genuine. Ang tunay na issue, kung dininay mong negligence, inamin lahat Yung amount lang ang pwedeng ma-summary judgment. So, pagbabatayan ng court sa summary judgment yung admissions, affidavits, depositions, pleadings. Okay. Nag-file ako ng complaint to recover usurious interests. Yun ang aking complaint, to recover usurious interest. Kasi I allege that your interests are usurious. I want to recover the interest I paid. You denied in your answer. I vehemently deny that the interest charge was usurious, period. Though I still have to prove later on that the interest was usurious. Meron pa ba akong factum probandum to prove that the interest was usurious? No more. When he says he denied the usury, he was admitting it because the facts of the case did not show that his denial of the usury was under oath. It has to be under oath. Otherwise, the usury will be deemed admitted. You look at Section 11 of Rule 8. You look at the second sentence. Go back to that. When you want to deny an allegation of usury, you have to deny it under oath. Otherwise, you are admitting the usury. But no, the allegations of usury you have to deny under oath is an allegation of usury in a complaint. And that complaint is filed to recover usurious interest. In other words, allegations of usury which are not designed to recover the interest need not be denied under oath. A mere specific denial is sufficient. But the word complaint does not necessarily refer to literally a complaint. It refers to a claim. It could refer to a cross-claim. It could refer to a counterclaim. Because the word complaint there is used in a generic sense. If your counterclaim is filed to recover usurious interest, it's covered by that provision. But if your allegation of usury is alleged only as a matter of defense, you don't need an oath to deny it. A specific denial is enough. Okay, practice. I filed an action for foreclosure of real estate mortgage. You denied in your answer the genuineness of that deed of real estate mortgage. Do I have to prove something? Is there a factum probandum? None. The facts of the case do not show that your denial of my actionable document was under oath. If you want to deny the genuineness of my actionable document, which was the basis of my suit, you have to deny it under oath. Okay? Let's try. Just practice for a little while if you need a factum probandum here. An information for forcible abduction was filed against the accused. He entered a plea of guilty. Is there still a need to prove his guilt? No. When you enter the plea of guilty, no more factum probandum. Well, it's not a capital offense. How do you prove the factum probandum? What's the term you use? The factum probans. Actually, factum probans is the means to prove the factum probandum. It's actually the evidence. The word corpus delicti is a Latin term, literally meaning the body of the crime. Delicti is crime. Corpus is the body. But does the word corpus delicti always refer to the body of the person victim of homicide or murder? No. The word corpus delicti means the body of the crime, meaning the elements of the crime. If you prove the elements of the crime, there is corpus delicti. Can a person be convicted of homicide or murder even if the body is no longer found? Oh, the answer is yes. As long as it could really be proven that there was death and that there was an act resulting into the death. Well, this is an old doctrine borrowed from America. This is an old doctrine in the Philippines found as early as 1950. And there was a case here like People versus Ansang. This happened in Mindanao. This was about several men riding a vinta and throwing dynamites at another vinta. The victim's vinta exploded. Of course, the person inside that vinta also exploded. There were witnesses because there were other people in several bangkas. You know, the body was never found. This was in the sea, a deep portion of the sea. And several days after the incident, the fragments, the wooden fragments of the vinta were washed ashore. But there was no body found. Because there was a use of explosion, Mr. Ansang was accused of murder. And his defense was very simple. If you said, I killed someone, where is the body? No body, no body, no conviction. Philippine Supreme Court said no. There were certain circumstantial evidence against you. You threw dynamites. The vinta exploded. The explosion elevated the body of the victim. He was blown to smithereens. He was never found. There is murder. If you are from Cebu, you might have heard when you were still young, this was around 12 years ago, or almost 14 years ago, the case of People versus Laraniaga et al. Where two young ladies, Mary Joy and Jacqueline, were abducted. Only Mary Joy's body was found. The main witness, Mr. Russia, alleged that there was murder and there was rape. But were they convicted of double murder? Yes. Even if one body was not found. Because of evidence, through testimonial evidence, that there was really a killing, there was really a murder. But the meaning of corpus delicti came from America, actually. It was at that time when airplanes were first used as commercial transportation. There was this man who boarded a plane, and at that time there were still no X-ray machines in airports. And while the plane was around 25,000 to 30,000 feet above sea level, he calmly stood up, went to the back, and asked a guy at the back to stand up. Then he drew a .45 caliber pistol. He asked the guy to stand up, put him on the wall of the plane, shot him twice, bang bang on the chest, and once in the head, and ordered the plane steward to immediately open the back door. Well, it will result in decompression. Immediately open the back door and push the victim. and immediately closed the door before a full decompression of the plane to the court. Without him knowing, the pilot radioed already the police in the airport. So when he got down, he got off, there was a big welcome party for him. He was accused of voluntary manslaughter, which means murder. His defense: where is the body? Find the body first. There is no corpus delicti. The Maryland Supreme Court said there is. There was evidence that there was death. The witnesses said you shot him with a 45 caliber pistol, twice in the chest and once in the head. Only one bullet of a 45 caliber is capable of killing you. Then you pushed him from 25,000 feet above sea level? Will he fly? The body was never found. He was convicted of voluntary manslaughter because in murder and homicide, you don't have to present the actual body. But when the case is, for example, sale of illegal drugs, no drugs identified beyond reasonable doubt, no conviction. When you talk about corpus delicti and drugs, you have to identify the drugs as the very drugs that were confiscated, let's say during a buy-bust operation. So with respect to drugs, the corpus delicti includes identification of the drugs because the corpus delicti includes the drugs. You will know that part of your syllabus is Republic Act 9165. And Republic Act 9165 is the Comprehensive Drugs Law of 2002. That's part of your syllabus. That's why when you read, you have to read Section 21 of the drug law, because you have the topic called chain of custody. Okay, in theft or robbery, as long as it can be proven that there was really an unlawful taking, like in theft, even if the thing stolen is not found, there could be conviction for theft. There could even be conviction for robbery. Kasi pag ninakaw, minsan, dinidispose of na, right? Yes. Eh kung nawala na, ninakawan ako ng relo ngayon, nahuli yung magnanakaw, wala nang relo. Dinispose of na niya, hindi natin alam kung saan niya na-dispose of o kanino binenta o kanino binigay. Ibig bang sabihin, hindi mo siya pwedeng i-convict ng theft? You could. Because there, the corpus delicti does not require the presentation of the things stolen. Unlike in drugs. You really have to present the drugs, you have to identify the drugs with certainty and beyond reasonable doubt.